rise. Be seated, please. Good morning. I'm Judge Elwood Brown, and this is the beginning of our St. Clair County Mock Trial Tournament. Third year that we've had this. The judges in this court, I'm going to allow to ask that they introduce themselves and tell you a little bit about their background so that you have some understanding of their professional experience. And I guess we'll begin with Cindy Lane.
Thank you. I'm Cynthia Lane. I'm a lawyer in private practice. I've had, over the course of about 26 years, I've had both a criminal and a civil practice.
I'm Pat Politano. I've been an attorney for 8 years. I have practiced in both civil, criminal, and family law in front of Judge Brown, and I've worked with some of the attorneys here.
I'm Anna Kovar. I'm working in private practice now. I have never practiced criminal law, so this will be interesting for me.
My name is Keith Bankson. I'm a longtime attorney in Port Huron, and for the past 5 years I've been a district court magistrate.
My name is Mark Davidson. I'm also in private practice since 1975. I belong to a law firm called Hill Dievendorf, which was established in 1871 in Port Huron.
And I'm Judge Elwood Brown, and I am the judge of the family court here in St. Clair County. I've been a judge for, I'm in my 9th year. I'm in my 29th year of practice, and I spent 17 of those 29 as in the prosecuting attorney's office, 7 of which I was the prosecuting attorney. So I'm pleased to welcome all of you here, and we're going to begin then at this time. The attorneys for each side, please identify themselves for the record.
Good morning, I'm Travis Lenoy. I will be directing Detective Hillenbrand as portrayed by Chris Runge and cross-examining Cameron Wolf.
Good morning, I'm Abby Clark and I'll be directing Evan Bailey, portrayed by Amanda Forbes, and crossing Morgan Phillips.
Good morning, I am Tim Hischke. I am directing Robin Anderson, as portrayed by Haley Tanton, and I'm crossing Pat Hoffman.
My name is Pat McCollum. This is Chris Timchuk and Kristen Husky, and we are representing Morgan Phillips.
All right. Plaintiff may give their opening statement.
Your Honor, I would like to know if we are free to move by the law of court.
You are free to move as long as you don't get too close to the jury and stay relatively close to the microphones.
Thank you.
Ladies and gentlemen of the jury, we call you here not to do simply a task or to fulfill a duty, but to help or to put in this guilty murderer behind bars. The evidence will show 5 indisputable facts, which are as follows. 1, that the car that the defendant was driving matches the testimony given by Evan Bailey. 2, you will hear from Detective Hillenbrand that the cigarette butts that were in the alleyway match the unique brand that Morgan Phillips is known to smoke. 3, that Morgan Phillips's gun was found relatively close to the crime scene. And 4, the evidence will show that the defendant has a gap of time in which she has no alibi. And 5, the defendant has a motive to kill one Mitch Stevens. And that Robin Anderson witnessed a physical altercation between Mitch Stevens and Morgan Phillips. I'm confident in saying that the evidence will show that Morgan Phillips was indeed did indeed commit first-degree premeditated murder. And that he intentionally and deliberately shot one Mitch Stevens. And the testimonies you will hear will show that because he was angry about Mitch Stevens throwing a game of basketball in favor of Miller, that he killed Mitch Stevens. Nothing further.
Defense wish to give their opening statement now or reserve it till later?
We do, Your Honor.
Go ahead.
Ladies and gentlemen of the jury, you are here today to decide the fate of Miss Morgan Phillips. Miss Phillips is accused of first-degree murder. In order for you to find Miss Phillips guilty, the prosecution must prove beyond a reasonable doubt these 5 elements. First, that Miss Phillips caused the death of Mitch Stevens. Second, that Miss Phillips intended to kill Mitch Stevens. Third, the intent to kill was premeditated. Fourth, the killing was deliberate. And fifth, the killing was not justified or excused. The prosecution must prove all of these elements in order for you to find Miss Phillips guilty. However, by the end of this trial, you will believe Miss Phillips is not guilty of the charges and that the detective investigating the case made a rush to judgment while deciding on the chief suspect. During the course of this trial, you will hear testimony from 3 witnesses: Ms. Cameron Wolf, Mr. Pat Hoffman, and Miss Morgan Phillips. Ms. Wolf, a private investigator and expert in the area of organized crime in the Shapiro crime family, will testify to the very real possibility that Mitch Stevens was killed by the Shapiros, a possibility that the detective investigating the case did not look into because he made a rush to judgment. Mr. Hoffman, a longtime resident of East Auburn, will testify that he was with Miss Phillips the night Mitch Stevens died. Miss Phillips will also testify to her own innocence. These witnesses, the lack of proof shown by the prosecution, and the rush to judgment made by the detective investigating the case will create doubt that Miss Phillips is guilty of the charges. And once you have this doubt, I ask that you find Miss Morgan Phillips not guilty of the charges. Thank you.
Thank you. Prosecution may call the first witness.
Your Honor, the prosecution calls John Anderson to the stand.
Right up here, please.
Please raise your right hand. Do you promise that the testimony you're about to give will faithfully conform to the rules of the mock trial tournament?
Yes.
You may proceed.
Please state your name and spell last for the record.
Robin Anderson, Anderson.
And how did you know Morgan Phillips?
We owned a real estate business together.
All right, and are you still with that company?
No, I am not.
All right, could you give us a reason?
We didn't see eye to eye.
Objection, relevance?
What's the relevance?
I have no recount.
Well, I'm going to wait until to hear what she has to say, and I'll take your objection under advisement.
We didn't see eye to eye on how to handle tenants when they didn't pay rent and things of that nature, so I left.
All right.
Objection's overruled.
All right, and did you see her the night of February 10th, 2007?
Yes, I did.
And where was that?
At the Crosstown Classics basketball game.
And did you witness anything that Morgan Phillips did that night?
After the game, she was very angry about some calls made during the game.
All right, and could you please describe that?
Objection calls for a narrative.
Overruled.
After the game, I seen her go up to Mitch Stevens, grabbed him by the collar, and said, "You cost us the game, I'm going to kill you."
All right, and what happened after that?
After that, I left.
All right, and when did you leave?
At 5:10.
Can you be positive of this time?
Yes, I can. I know this because I looked at my watch to make sure I was going to be on time for a movie.
Nothing further.
Cross-exam.
Yes. Miss Anderson, is it true that you started Crosstracks Realty with Miss Phillips in 1997?
Yes, it is.
Is it also true that you left Crosstracks Realty after things started to go sour in 2000?
Yes, it is.
Is it not true that you started your own realty agency after leaving Crosstracks?
Yes.
And did you sign a non-compete agreement with Miss Phillips?
Yes.
Did Miss Morgan Phillips sue you for violating this non-compete agreement?
Yes.
How much did she sue you for?
I can't be positive of how much.
Do you recall making a statement to police?
Yes.
Would it help to refresh your memory if I were to show you this statement?
Yes, it is.
Your Honor, may I approach the witness and show her the statement?
No, you can't. Under the rules of mock trial, you cannot present anything to the witness.
Miss Anderson, is it not true that you said you would not mind helping put Morgan Phillips behind bars?
Yes.
Thank you. No further questions.
Redirect.
Did you lie at any time during your statement?
No, I did not.
Nothing further.
All right. You may step down. Next witness.
Your Honor, the prosecution would like to call Evan Bailey to stand.
Please raise your right hand. Do you promise that the testimony you're about to give will faithfully conform to the rules of mock trial tournament?
Yes.
Have a seat.
Please state your name for the record.
Evan Bailey,
Where are you currently living?
East Arbor,
How long have you lived in East Arbor?
since I was 18.
How do you know the defendant, Morgan Phillips?
He was my landlord.
Have you ever been in fear for your personal safety while in the presence of Phillips?
Objection,
Yes.
Your Honor, leading.
It was her personal account.
Yeah, wait a minute. You have to talk to me, not to the other lawyer.
Your Honor, it was her personal account of what happened.
Well, the objection is for leading questions, so ask a direct question. Sustain.
Did Phillips ever make you fear for yourself?
Objection, Your Honor, leading.
Rephrase your question.
Have you ever been in fear of your safety? Did Phillips ever make you fear for your safety?
Your Honor, leading.
I'm going to overrule your objection. You can answer the question.
Yes.
Describe the incident, please.
One day I was at my house and Morgan and Pat Huffman came over and he was yelling, screaming about the rent, and he threatened to hurt me if I didn't pay him.
Where were you on the night of February 10th?
I was out and I got home about 8:45.
When you arrived home, did you notice anything unusual?
Yes, there was a black SUV parked in the alley and I'd never seen it before.
Did you see anyone in the alley?
I thought I could see a shadow of somebody and it looked like they were smoking a cigarette.
Did you approach the person?
No.
What did you do next?
I went inside and took a nap.
When you took that nap, well, what happened next?
I was awoke by screaming in the alley.
Could you make out anything they were saying?
I know that they were screaming about the reffing at the Crosstracks Classic.
Objection, Your Honor, hearsay.
You have a response?
That was in her statement, Your Honor.
The witness has testified to something that she heard, so that's not hearsay. Go ahead.
Did you recognize the voice?
It sounded like Morgan Phillips.
What happened
Objection,
next?
Your Honor, speculation. She cannot see Morgan Phillips, so therefore she has to know.
Want to lay a foundation? All right, sustain.
What happened next?
Next, the screaming went on for a while, and then it was silent, and then I heard 2 gunshots, and I hit the floor.
Did you go into the alley after that?
Yes.
Describe what you saw in the alley.
I saw Mitch Stevens in a pool of his own blood.
Did you notice if the black SUV you described earlier was still there?
Objection, Your Honor, leading.
Sustain.
The black SUV mentioned, was it in the alley?
No.
What happened next?
Next, I screamed for 911, and within minutes, there was ambulance and cops.
Based on your personal experiences with Phillips, do you think it would be reasonable to assume he committed this
Objection, Your
crime?
Honor, opinion.
You have a response?
No further questions.
Sustained. Okay. Cross-exam?
Yes, sir, Your Honor.
It's not true that on several occasions you saw several thugs walk into Mitch Stevens' home?
Yes.
Is it not true that you knew these thugs were in the mafia and part of the Shapiro family because you've read about them in an article?
Yes.
Is it not true that you've had prior bad experiences with the defendant, Morgan Phillips?
Yes.
No further questions, Your Honor.
You have any redirect?
Did you at any point lie during your statement?
No.
You may step down. Next witness.
Prosecution would like to call Detective Hillenbrand to the stand.
Please raise your right hand. Do you promise that the testimony you're about to give will faithfully conform to the rules of my trial tournament?
Yes, sir.
Please state your name and spell your last for the record.
Detective Francis Lee Hillenbrand, Hillenbrand.
Where and when did you graduate from college?
From Miller College in '93.
What did you get your degree in?
Criminal justice.
How long have you been in law enforcement?
14 years.
Where did you start your career?
In the Chicago Police Department
When were you promoted to detective?
in the year 2004.
At this time, Your Honor, we request Detective Hillenbrand be qualified as an expert in crime scene investigations.
There was no stipulation prior to this trial that he would be considered as an expert.
According to these stipulations, it says no party may conduct void air of any expert witness. All expert witnesses were timely disclosed, and he was timely disclosed.
Well, you have a response to that?
I do not believe that he was he was considered an expert before the case.
Okay. No foundation has been laid at this point to establish him as an expert. He is not identified as an expert in the materials. And therefore, you either lay a foundation or your request is denied.
Do you know Morgan Phillips?
Yes, I do.
Could you please point her out in the crowd?
She's over there in the pants and the black and white shirt. Blouse.
How long have you known Phillips?
Ever since I moved back to East Arbor, we've had run-ins with him.
Objection, relevance.
This shows his violent tendencies, which had to do with the case.
You have to ask then a more direct question. You're asking a pretty general question on this. So rephrase your question.
Has Morgan Phillips ever had any run-ins with the law?
Objection, relevance.
Withdrawn. What were you doing the night of February 10th, 2007?
I was working when I received a call about 9:45 that there was a murder over near Heathcote Point.
When did you arrive at the scene?
About 10 o'clock.
What did you see?
I saw the paramedics examining the body, and it didn't take them long to realize that the body was dead.
Whose body was it identified as?
After looking through the wallet, I was able to identify the body as one Mitch Stevens.
What did you notice about the body?
I noticed it had 2 bullet hole wounds in the chest, and then after examining the forensic report, I was able to identify that he was in fact killed by the bullet wounds.
I would like to show opposing counsel. May I approach the witness?
For what purpose?
To show evidence.
Present the witness.
Could you please identify this?
This is the forensic laboratory report.
Your Honor, may I publish the exhibit to the jury?
You haven't asked it to be admitted yet.
Oh, sorry. Your Honor, I'd like to move the remission of Exhibit 1.
I object for lack of foundation.
It's the forensics report.
Forensics report and the materials has been stipulated to as admissible evidence, so.
I realize this, but there's no prior questions about the laboratory report. I'm objecting for lack of foundation.
Well, based on the stipulations in the rules here, it's admissible, so you may publish it if you wish.
Your Honor, may I publish this to the jury?
Go ahead.
What did you do after you found the forensics at the scene?
I canvassed the area and I found two 9mm bullet casings next to the body, along with some some Clark cigarette butts, and also I found under the air conditioning unit a 9mm handgun.
Were you able to identify the gun?
Yes, after running the serial number through the Sidearms Emporium, which is the only gun store in town, and through running it through our database, I was able to identify it as Morgan Phillips' gun.
May I approach the witness?
For what purpose?
Evidence of the gun.
You may approach the witness.
Please identify this.
This is the registration of Morgan Phillips' handgun.
Your Honor, I'd like to move for the admission of Exhibit 5.
No objection.
May be admitted.
Your Honor, may I publish the exhibit to the jury?
Go ahead.
What did you do after you identified the gun?
I went to question Morgan Phillips.
Did he have anything to say?
He's kind of...
Objection, yourself. Calls for yourself.
He questioned him in his line of duty.
Is that the exception to the hearsay rule you want to rely on?
Yes.
Well, it's admissible because it's the admission of the suspect.
He kind of seemed reluctant to answer my questions at first, but he finally let me in and answered a few of my questions.
No further questions.
Cross-examination.
Yes, Your Honor.
Good morning. Is it true that you were the detective that examined the scene on the night of February 10, 2007?
Yes, it is.
And is it true that Morgan Phillips' gun was reported stolen 4 hours before this murder occurred?
Yes, it was.
Is it also true that during the course of your investigation, it led you to a convenience store that Morgan had been to?
Yes.
Is it true that this convenience store had a security system, a surveillance system?
Yes, it is.
And what did this surveillance system consist of?
I didn't look at it. It was outdated and...
Did this system consist of a video camera?
Yes, it did.
And is it true that you did not take the time to investigate the tapes and did not review the tapes that
Yes, it
would
is.
show my client was there?
Yes, it did.
So you did not review the tapes?
No.
All right. Is it true that as an officer of the law, it is your duty to investigate all plausible leads in your cases?
Yes.
Is it true that you've also heard theories about how the murder of Mitchell Stevens has been mob-related?
Yes.
Is it true that you also did not investigate this lead also?
No, I didn't.
No further questions.
You're direct.
Did you lie at any time during your statement? No.
You may start. Are there any further witnesses from the prosecution?
No, Your Honor.
You resting?
Yes.
Your Honor, before we call our first witness, I would like to read some following pre-trial stipulations into evidence.
Wait a minute.
May I?
That's not necessary.
No.
No.
Okay.
Call your first witness.
Yes, we would, Your Honor. The defense would like to call Ms. Cameron Wolf.
Please raise your right hand. Do you swear that the testimony you're about to give will faithfully conform to the rules of the mock trial tournament?
Yes, I do.
Let's see.
Could you please state your full name and spell your last name for the record?
Cameron Wolf, W-O-L-F-E.
Ms. Wolf, what is your current occupation?
I'm owner and president of Wolf Investigations.
And what is Wolf Investigations?
We're a private investigation firm specialized in criminal defense.
And where did you work before starting Wolf Investigations?
I worked for 20 years with the Federal Bureau of Investigations.
What division of the FBI did you work in?
Organized crime.
And how much experience do you have in this field?
I've worked on hundreds of successful prosecutions.
What was your main focus while working in organized crime?
Attempts to take down the Shapiro crime family.
And what, if anything, has come out of your experiences?
I've authored a book on the family.
What was discussed in your book?
Their routine practices, their day-to-day business, how they operate their crime syndicate.
Your Honor, I would like to have this witness declared an expert witness in the area of organized crime and the Shapiro crime family in particular.
Any objection?
No objections.
All right. Based on the lack of objection to the issue, I'll grant you request.
Ms. Wolf, how did you become involved in this case?
The defense team defending Morgan Phillips contacted me and asked for my help.
And what did you do after they retained your services?
I reviewed the police and forensic lab reports related to the incident.
I would like to draw your attention to Exhibit 1. Are you familiar with this exhibit?
Yes, I am.
Your Honor, may I approach the witness to hand her Exhibit 1?
You want to identify the exhibit for the record, please?
The exhibit is the Michigan State Police Crime Laboratory Crime Laboratory Division Forensic Laboratory Report from February 12, 2007.
You may approach the witness. However, you can't leave the exhibit with the witness.
Was this one of the
Did you retrieve it from the witness?
Was this one of the documents you reviewed in the course of your investigation?
Yes, it was.
Have you reviewed police reports and lab reports such as this before?
Yes, several during my time with the FBI, and also I still do as a private investigator.
And what is the cause of death listed as for Mitch Stevens?
2 gunshot wounds to the chest.
According to the report, how did the bullets enter his body?
At a downward angle.
And according to the report, what is this consistent with?
A standing shooter and a kneeling victim.
Ms. Wolf, would this be something you would see in a typical Shapiro execution?
Absolutely. It's their signature execution move.
What did you discover while investigating Mitch Stevens' life?
He made several large betting wagers on sporting events.
And what did you do after discovering this information?
I located the local bookie, Eustace McGee.
Did he give you any helpful information?
Not at first. He didn't want anything to do with me.
And did you speak with Mr. McGee again?
Yes. After I heard he was shot, I went down to the local hospital to see if I could talk to him.
And what, if anything, did Mr. McGee say to you?
He said he was sure he was going to die, and he wished he'd never gotten mixed up with the Shapiros.
Did you ask him anything after that?
I asked him what he meant by that.
And what was his response?
He said he was shot because the Shapiros believed he was in line with Stevens.
And according to McGee, why did Stevens come to him?
To place a bet on Miller to win the Crosstown Classic.
And according to McGee, what was Stevens' attitude when he came to see McGee after the game?
He said he was very happy.
Did Stevens tell McGee why he was so happy?
Because he said he had just pulled a fast one on the Shapiros.
Did McGee say what Stevens meant by this?
He said that he was deeply in debt to the Shapiros and offered them to throw the game in favor of Logan, but he actually threw the game in favor of Miller and placed a large bet on Miller to win.
And what did McGee say Stevens planned to do when he showed up to collect the money?
To take the money and run.
And what did Mr. McGee do?
He paid him the money that he had won.
Did Mr. McGee give you any other pertinent information?
I'm not sure I understand the question.
Did Mr. McGee make any other statements to you involving anything he might have seen a couple days later?
Oh, he said that a couple days later, somebody from the Shapiros came down and threatened him for being in line with Stevens.
Did Mr. McGee offer any evidence to confirm his story?
He offered me the betting slip from Stevens.
And how did you know you had taken the right piece of paper?
I showed it to him to confirm that it was the correct one.
Your Honor, may I approach the witness to show her Exhibit 7?
Okay. Want to identify it first?
The betting slip. Miss Wolf, would you please tell the court what this is?
It's the betting slip from Stevens.
According to the slip, how much did Stevens bet?
$10,000.
Thank you.
Cross-examination.
Yes, Your Honor. Miss Wolf, isn't it true that in 1999 you were fired from the FBI?
Yes.
Isn't it true that the reason you were fired is because you embezzled money from your former employer, yes or no?
Objection, relevance.
Withdrawn. Isn't it true that you told the law firm of Morgan Phillips if you didn't find anything you wouldn't charge them?
Objection, relevance.
This has to do with the case and shows that she is working for Morgan Phillips and that she has some kind of reason to find something in this case.
It's relevant as the bias.
Can you repeat the question?
Isn't it true that you told the law firm of Morgan Phillips if you didn't find anything you wouldn't charge them?
Yes.
So it was in your best interest economically to find something in this case, yes or no?
I always do the moral thing, so if there was nothing
Yes
there...
or no?
Can you repeat the question?
So it was in your best interest economically to find something in this case, yes or no?
I wouldn't have lied to make money.
Yes or no?
You can answer the question without yes or no. It's necessary.
What is the price you charge per hour?
I can't remember.
Were there any other expenses you charged to Morgan Phillips for this case?
Objection, relevance.
Withdrawn. How much did you charge to Morgan Phillips?
Objection, relevance.
This has to do with the case because she is here today charging money for being here.
It has to do with, it's relevant as to, it relates to her interest in the, giving her testimony.
Can you repeat the question?
So in total, how much is this going to cost Morgan Phillips for your services?
I can't recall.
Would $7,000 be about right?
Sounds right.
No further questions.
Redirect.
No, Your Honor.
Now, if you have time left, you can read into the record any stipulations that you wish, but you need to do it.
Yes, Your Honor.
Do you have any stipulations you want to read into the record? She needs to do it.
Yes, Your Honor. The betting slip is hereby deemed admissible as an exhibit. Any attack is limited to weight rather than admissibility. The names of the other individuals listed in the betting slip are irrelevant and have therefore been redacted.
Okay. Your next witness?
Hans calls Pat Hoffman.
Please raise your right hand. Do you promise the testimony you want to give along all rules of the mock? Yes.
Good morning. Could you please state your name and spell your last name for the record?
My name is Pat Hoffman, Hoffman.
And how long have you lived in East Arbor?
All my life.
And where do you work?
I work at the Strathcole factory on our packing line.
And are you familiar with Morgan Phillips?
Yes, we've been friends since childhood.
And did you go to high school with Ms. Phillips?
Yes, I did.
And after high school, did you remain friends?
Yep, we roomed together for 3 years and attended basketball games regularly.
And how was Morgan's attitude towards the game of basketball at this time?
She became very enthusiastic about the game and was always the first to boo the ref or heckle the other team.
Let me draw your attention to February 10th, 2007. What did you do on that day?
I attended the Crosstown Classic with Morgan, as I always did.
And what, if anything, happened during the course of the game?
The referee was making some bad calls, so people began chanting.
And which team won?
The team Morgan and I wanted to win lost.
And how did Morgan take this?
Morgan was very upset.
And did Morgan do anything with this being upset?
Yeah, I saw out of the corner of my eye that Morgan was running down to the court to confront the referee.
And what did you do in response to this?
I immediately followed her.
And when you reached Morgan, what did you see?
I saw Morgan confronting the ref and saying how she had the ref had blown the biggest game of the year.
And what did you reply to this?
Well, I immediately took Morgan out of the court.
And was Morgan the only fan at the game that was angry?
No, there were many fans that were chanting and booing the ref.
And have you ever seen Morgan angry at a basketball game before?
Yes, many times, including a time with Robin Anderson in 1995, big argument.
Has Morgan ever gotten violent over a basketball game?
I've seen arguments, but nothing physical with Morgan.
Okay. Let me take you back to the night of February 10th, 2007. What did you do after the game?
Well, I knew that Morgan was really upset, so I just suggested that we go to a shooting range to release some tension.
And so what did you do next?
We stopped by Morgan's place, but we ran into a bit of a problem.
And what problem was that?
We found that Morgan's gun was missing.
And what did you do? Did you do anything about the missing gun?
Yeah, Morgan called the police station, reported it stolen.
All right, and what did you do next?
I told her that she could use one of my guns, so we went shooting anyways.
Okay. After going shooting, did you do anything else?
Yeah, we stopped by Lackluster Video and rented V for Vendetta, along with other videos.
And was there a receipt of this movie rental?
Yes, there was.
Got married, force a witness to show Exhibit 6.
Identify what it's
the video receipt.
All right, you may approach the witness.
Yes, it is the customer copy of my receipt.
And the defense moves for admission of People's Exhibit 6 into evidence.
Any objection?
No objections.
Exhibit may be received in evidence.
Thank you. So what did you do when you got back to your place?
We put in V for Vendetta and watched it.
All right, did you watch the entire movie?
Yes, we watched the ending, and we especially hated the ending.
And how did Morgan react to the ending?
She was very upset, but it made her forget about the last game.
And do you recall what time you rented the movie?
Yes, it was 5:45.
Your Honor, may I approach the witness?
No.
Okay. Are you sure that's the correct time? No?
I can't recall.
Okay. What did you do after the movie?
Morgan told me that she needed some smokes, so I let her borrow my SUV to go get some.
And how long was Morgan gone?
10 or 15 minutes, no longer than that.
All right. And what did you do when Morgan got back?
We put in another video, and I fell asleep real quickly.
All right. No, thank you. No further questions. And may I publish this to the jury?
Go ahead. Cross-exam.
Yes, sir.
All right. First of all, I want to point out one thing here, and that is when I asked questions whether there was any objections to the admission of the exhibit, this lawyer stood up and said, no, it should have been you. Okay, so go ahead.
What kind of car do you drive?
A black SUV.
All right. And isn't it true that you were drinking that night?
Objection relevance?
It's perfectly relevant to this case.
Well, wait a minute, you need to talk to me. You can't talk to the other lawyer. Go ahead. Why is it
perfectly
relevant?
relevant to this case because it has to deal with this mental stability as a person.
As to his, do you respond to that?
His mental stability, he perfectly remembers everything that happened that night. It's not relevant if he was drinking or not.
Well, it perhaps has relevance as to the ability of him to remember and whether or not we should believe his memory. You may ask the question.
All right. Is it true that you were drinking that night?
Yes, I had a little bit.
All right. Was it? Do you remember the time that Morgan Phillips left?
I can't recall.
All right. No further questions.
Redirect? No?
No, Your Honor.
All right, you may step down. You're our next witness.
Yes, Your Honor, we would like to call the defendant Morgan Phillips to stand.
Please raise your right hand. Do you promise testimony you're about to give will faithfully conform to the rules of the mock trial tournament?
Yes.
Would you please state your first and last name and spell your last name?
Morgan Phillips, Phillips.
And where do you currently live?
I live in East Arbor, and I've lived there all my life.
And what college did you attend? What's your current profession?
I own Crosstracks Realty. It's a real estate business, and we sell and rent homes inside and out of East Arbor.
And where did you go to college?
I attended Logan University.
And are you still affiliated with Logan?
Yes, I'm the president of the Logan University Basketball Boosters program.
And do you receive any perks from being the president of the Logan University Basketball Boosters program?
Yes, I get really good tickets to all the games, including the Crosstown Classic.
And what is the Crosstown Classic?
It is a rivalry basketball game between the two colleges, Logan and Miller, that happens only once a year.
And did you go to this year's Crosstown Classic?
Yes, I went with Pat Hoffman.
And what, if anything, unusual happened at this year's Crosstown Classic?
There were a lot of bad calls made by the referee, Mitch Stevens, all in favor of Miller.
How did you react to these calls?
It made me really upset since I'm a huge basketball fan.
And how did the crowd react to these calls?
You could tell that everyone was upset by the calls. The officiating was terrible.
So you weren't the only one upset that day?
No, there were a lot of other people upset.
Now, the official that made these calls, Mitch Stevens, have you ever seen him referee a game before?
Yes, I've seen him referee many Logan basketball games before, and he's never done this bad of a job.
And how is his refereeing different this day than it was in the previous games?
He was constantly making terrible calls, all in favor of Miller.
And what did you do after the game?
Me and Pat decided to go shooting to relieve some stress since we were so upset over the game.
Did you go straight to shooting?
Well, first we went to my house, but when we got there, my gun was missing.
And what did you do when you couldn't find your gun?
I immediately called the police.
Do you remember what time this was?
It was 5:45 p.m.
So you went home, your gun wasn't there, and you called the police. What did you do after that?
We had to go to Pat's house to get a couple other guns.
After getting Pat's guns, did you go straight to shooting?
Yes, we went out to a farm that we always go shooting at.
About how long did you shoot for?
Around an hour to an hour and a half.
And what did you do after shooting?
We decided to go get some movies.
And who paid for these movies?
I did.
Your Honor, I would like to approach the jury to receive Exhibit 6, the movie receipt.
You may.
May I approach the witness, Your Honor?
For what purpose?
To verify the time at which these movies were running.
You cannot present anything to the witness to testify from. Just testify from her memory.
Okay, thank you, Your Honor. May I republish it to the jury?
You can just hang on to it.
Okay. And do you remember what time these movies were running?
Yes, we rented them at 7:45 p.m.
And where'd you go after the movie store?
We went to Pat's house and started watching the first movie.
Do you remember what this movie was about?
It was about some guy blowing up London in a mask.
Your Honor, I would like to admit some of the pretrial stipulations.
Go ahead.
And the runtime for this movie, V for Vendetta, is 133 minutes. What did you do after this movie was over?
I needed to go get some cigarettes, so I left Pat's house.
And what did you do after getting the cigarettes?
I came back to Pat's house and we watched the rest of the movies.
Did you stay there that night or did you return home?
No, I left after the movies were finished and I was awakened in the morning by the police at my house.
What did the police do when they got there?
They asked me a bunch of questions and then I was arrested for the murder of Mitch Stevens.
On the night of February 10th, 2007, did you murder Mitch Stevens?
No.
No further questions, Your Honor.
Cross-examination.
Isn't it true you attended the Crosstown Classic basketball game this year with Pat Hoffman?
Yes.
Isn't it true you have attended this game for nearly 32 years?
Yes.
So would it be correct to say that this is a game that's very important to you?
Yes.
Isn't it true that you hate to see your team, Logan, lose?
Yes.
Isn't it true you believe Logan lost the game because the referee, Mitch Stevens, made calls favoring Miller?
Yes.
Isn't it true the calls Stevens made angered you?
Well, since I'm a huge basketball fan, they made me pretty upset.
Isn't it true you confronted Stevens about these calls after the game?
Yes.
Isn't it true Pat Hoffman had to force you away from Stevens?
Objection, Your Honor. That's not in her testimony.
Well, she's not limited to her direct examination for the cross-examination, so the question may be asked.
Isn't it true Pat Hoffman had to force you away from Stevens?
I do not recall that happening.
After the game was over, you were still very angry, correct?
Yes.
Isn't it true you and Pat Hoffman then went to get your guns to go shooting?
Yes, that's true.
But when you went to get your gun, you couldn't find it, correct?
Yes, it was missing.
Isn't it true you then notified the police of your missing gun just to cover your tail?
Well, I didn't want anyone to think that...
Yes or no?
Yes, I called the police because my gun was missing.
If you had simply misplaced your gun the way you said you did in your statement, you would have no reason to contact the police. Isn't that true?
Again, objection, Your Honor, speculation. For the reason why she's reporting her missing her stolen gun.
It's an appropriate cross-examination question.
Can you repeat the question, please?
If you had simply misplaced your gun the way you said you did, you would have no reason to contact the police. Isn't that true?
No.
You and Pat Hoffman headed to Pat's house to watch some movies after going shooting, correct?
Yes.
During the movie, isn't it true you left to get some Clark's cigarettes?
Yes.
And when you left to get the Clark's cigarettes, isn't it true you borrowed Pat's black Escalade?
Yes, because my car was out of gas.
Are you aware that a vehicle similar to Pat's was seen at the crime scene?
Objection, lack of first-hand knowledge.
Your response?
It's in her statement, Your Honor.
Well, then restate your question.
Okay. A vehicle similar to the one you were driving that night was seen at the crime scene, correct?
Objection, Your Honor. My client was never at the crime scene. She does not know what was going on there.
Well, that's kind of adding something to the, your objection kind of adds some facts that aren't in evidence, doesn't it?
I'm sorry, Your Honor. Her witness statement never mentions anything of her being there.
Your response?
It's a fact that can be inferred by the information in the statement.
And what, you want to address that part of the statement that she had? Can you identify where that's at?
No, Your Honor.
All right.
Withdrawn.
Sustained then.
When you arrived back at Pat's, you watched another movie, correct?
Yes.
During this movie, isn't it true Pat fell asleep?
Towards the end?
Isn't it true you then left when he was sleeping?
Yes.
Isn't it true that there are periods of time where you have no alibi?
Well, I was at
Yes or no?
Pat's house. I guess not.
No further questions, Your Honor.
All right, redirect.
Yes, Your Honor. Why did you take Pat's car instead of your own?
My car was out of gas.
And why did you go to this store to buy Clark cigarettes?
Because that's the only kind of cigarettes I smoke, and that's the only store that sells them in East Ever.
No further questions, Your Honor.
All right, you may step down. Does the defense have any further witnesses?
No, Your Honor. Defense rest.
At this time, I'd ask the prosecution if they're prepared to give their closing argument.
We are, Your Honor.
Go ahead.
Ladies and gentlemen of the jury, you have heard testimony that explains why we believe Morgan Phillips is guilty. Like my esteemed colleague stated earlier, the car Morgan Phillips drove that night was identical to the one Evan Bailey spotted by his house. The cigarettes found at the scene, which were sold at the convenience store only 2 blocks away, were identical to the ones found at the scene. The gun found at the scene is indeed identified as Morgan Phillips' gun. And lastly, you've heard that there's a time in which the defendant had no alibi. This murder is a senseless and sadistic way for the defendant to get revenge for a pointless basketball game. It's sad to see that sports are now a determination of life and death.
Defense?
Your Honor, ladies and gentlemen of the jury, thank you for hearing our case today. I would first like to state that the prosecution's case is entirely circumstantial, and these circumstances do not make any sense. You've heard testimony from Cameron Wolf. Cameron Wolf investigated another side of the case, a side in which Detective Hillenbrand chose not to investigate. Cameron is an expert in the Shapiro family mob, like the mob family, and testified that this killing was extremely similar to the typical Shapiro execution style. Cameron also uncovered the fact that Mitch Stevens had a serious gambling problem. Over the last few months of his life, Mitch kept making bigger and bigger bets and to get even, and predictably, this did not work. Wolf also uncovered the fact that Mitch Stevens was offered a deal. He was offered a deal by the Shapiros that would, for the game to be thrown. And instead of doing that, he threw the game for the other side. This would give the Shapiros motive to kill him. It only makes sense that the Shapiros would kill him in cold blood in their trademark execution. You've heard testimony from Detective Hillenbrand. As an experienced officer of the law for 14 years, you would expect him to gather evidence and he would follow up on all plausible leads. This, however, was not the case. Detective Hillenbrand rushed to judgment before even conducting a full investigation. He discovered the stolen gun and some cigarettes lying on the ground, and that was enough to arrest Morgan Phillips. Detective Hillenbrand was so concerned with accusing Morgan Phillips that he ignored all of the leads in this case. He went so low as to decline to review store surveillance tapes, which would show what time my client entered the store, because it would have been too much work. Too much work? How can someone call themselves a professional after doing something as low as that? You have heard testimony from Pat Hoffman and Morgan Phillips. Both their testimonies have shown that from the time of the game until after the murder was committed, they were together. Pat Hoffman drove Morgan Phillips back to their house. They discovered that the gun was missing, and they went to the shooting range. This would explain the gun residue found on Morgan's clothes. Hoffman also testified that he and Morgan rented the movie at Lackluster Video. This was confirmed by a receipt, which was time-stamped at 7:45 p.m. Hoffman also testified that he and Morgan watched the entire movie together before Morgan left to buy cigarettes. They rented the movie and went back to Pat's house to watch it. Even if they started watching the movie at the exact time that it was rented, the movie was 133 minutes long, that would put them at 9:58 p.m. and the murder was committed at 9:30. This makes it impossible also for the shadowy figure seen by Evan Bailey to be my client Morgan Phillips. This also makes it impossible for Morgan Phillips to have shot Mitch Stevens because the movie could not have ended until at least 9:58 p.m. The open window where my client supposedly has no alibi was after the murder was already committed. Ladies and gentlemen of the jury, these facts that I've just told you is what is known as reasonable doubt. The defense asks that you find Morgan Phillips not guilty of all charges. She is simply the easiest target to pin this on, and that is exactly what the prosecution is trying to do. Thank you.
You wish to give rebuttal? All right. As much as we've already heard all the evidence and the arguments of the lawyers, the jury will now retire to the jury room to make a decision as it relates to this case. We'll be in recess for a few minutes for that purpose.
All rise. You may be seated.
Be seated, please. All right, as a jury, we've had an opportunity to consult with one another and discuss this case. And at this time, I'm going to ask the judges who are in the jury box there to give you some statements as to their impressions. So we'll begin with Cindy Lane.
Well, I know this is the first time you've done this, and probably the first time you've done it in this particular tournament, and probably the first time that you that you've involved yourself in this program. I think that all of you knew the material really well. At times, I think because it's the first time in this tournament, and because it's new to most of you, in a general sense, that you were probably all a little bit nervous. And that's understandable, given the setting that you're in. Just so you know, in real life, real trial lawyers are nervous too. So I don't think that's a bad thing. I believe that when, as you participate in additional rounds, you'll feel a little more at ease. You'll always be a little bit on edge, and that's a good thing. I think one of the things to remember is that when someone objects, don't panic. And don't necessarily concede the objections. Just take your time, think through the nature of the objection, and then respond accordingly. Sometimes, and again, this often happens with many new lawyers, someone objects to your question and you kind of inwardly panic and you're not quite sure what to say. But just take a moment, think it through. You shouldn't be in too much of a hurry, and then it'll come to you. It really will. But I think you all did a very good job, and that you just, as time goes on, these things will occur to you as you get into the further rounds.
Mr. Napolitano?
I would concur with a lot of what Cindy said. I think a key thing, and obviously all of us have been doing this for a while, we went to law school, but don't let the objection throw you off. I think a lot of times you guys conceded things and just withdrew things, and you really had a response and you kind of had the other side. And I think as the day goes along, those things will become more crystallized in your mind and you'll be able to respond to the objections better. I think sometimes attorneys use objections to throw other attorneys off intentionally, and responding to that is crucial. You never want to just say, I give up or I withdraw the question unless the judge makes a ruling against you. Then you can withdraw or just go on. So I think another thing, when you're doing your opening and closing statements, a lot of times these little lecterns here, they're good things because you can put notes on and there's a place to put your hands so you're not. But when you're talking to the jury and you're opening and closing, that's your chance as an attorney to really start to have a relationship with the jury. You want to be completely facing the jury. Come talk to the jury like you're talking to a friend when you're having dinner or something like that. It's more persuasive if you're looking someone right in the eye and your whole body is just facing them. And I think the last thing is, and I think this is for cross-examination questions, sometimes the witnesses don't give you the answer that you want, or they say, I don't remember. A lot of times when people say, I don't remember, it's because they're lying and they don't want to tell you the truth. Think about it and follow up with that. Build your foundation with them. Go slowly through it, exactly what you want them to say. Because if you build your foundation and ask the question the right way, you can put the witness in a position where they have to give you the answer that you want. And I think all these things are just things, as you guys go along and do this, that will become more and more obvious and more evident, easier for you to do. They're things that I think all of us would say we fail to do sometimes. So it just takes practice and experience. But I think you guys all did a really good job.
Anna, go ahead.
Again, I think that they both have great points. The only thing I would like to add is that I think that when you portray yourself with confidence, whether you're right or wrong, and whether you're, I noticed that one of the defense team had a little more confidence than the prosecution in some instances, and I felt like their points came across more as a reality than the prosecution's. And again, it's because of how they portrayed themselves to the jury. And so a lot of times, whether you're right or wrong, if you can convey that sense that your side of it is more of a reality, more of a fact, more believable, whether it is or not, you're convincing a jury. So that's the only thing I would like to add. I think you did a great job.
Mr. Bankson?
Good job, everybody. Slow down. What you're saying to me, I have a little trouble keeping up with. Slow down. When you're making a point, slow down and make that one point. One more specific comment is prosecution might consider using that rebuttal. Even if you want to stand up and make one important point, I'd encourage you to use the rebuttal argument at the end of the case. Good job, guys, everybody.
Mr. Davison?
I want to pick up on that too. The rebuttal for the prosecution is very important. It's the last chance. You have the last shot, and you're the one who's trying to prove that the defendant is guilty. And a lot of times, I worked as a prosecuting attorney for a couple of years and did a lot of jury trials when I did that. And sometimes we actually kind of like save up, put a little bit of out there in the main thing, and then save some good ones, because that's your good chance to get that. The opening statement, make sure you cover all the elements. I mean, it's not just enough to kind of quick say what the facts are going to be, but especially the prosecution. Now, you have to kind of tell us. I mean, if we were jurors, real jurors, we don't really know anything about the law, so you have to kind of fill us in. Not just, and this is in the rules too. You're supposed to make sure you cover the elements as well as what you think the facts are going to show, and I don't think you did that. I compliment the defense team because they did a very good job of saying what these elements were and how they were going to show that it didn't get done. And again, I know this is your first round. I've been judging these since it started, and I see some familiar faces. So I know some of you are veterans of this, and it shows. I mean, that experience does help, and so all of you who are just starting, believe me, you're gonna get the same benefit. You're gonna get more confident as time goes on, and as Chip says, slow down, speak up. Make sure that you can be heard. Keep up the eye contact. That's very important. I know you kind of have your notes. And remember this. I know it's a good idea to sort of have your questions laid out, and you've been practicing with your witness, but you're kind of performing here too. You're doing a little acting, and when you're a witness, don't be afraid to do it. Pretend. Put yourself into the role, and well, if I were up here, I wouldn't want to admit that. But again, good job and good luck as the tournament goes on.
Well, one other thing that I'd observed, just as a practical comment, try to speak a little louder. Sometimes I had problems hearing some of you. So just remember to keep your voice up so that we, and think of us as the jury, can hear you and understand your questions and understand the witness's answers as well.
First of all, I want to compliment both teams and their attorney coaches. I know it took a lot of work and everything to get to this point. And I would be willing to bet that because of all the work you placed into this, you probably know the facts of this case and the rules inside out. So you are in the unique position to be able to present your case without having to rely on notes to the extent that you did, both of you. When you try a case in front of a jury, it's all about communication. And it's all about, it's really a performance. It really is for lawyers to perform before a jury in not only presenting the evidence that they have and asking the appropriate questions, but to get the jury to follow along with them and to go with what their position is. So it's all about communication and how you do that. Now, if you are relying entirely on notes, that interrupts the flow of communication. And Levi, for example, you did a good job testifying. You knew it, but it came out like rapid fire. Boom. I mean, your answers were so rapid fire. It's like anybody, a real witness up there would say, the jury might say, well, this guy's rehearsed this, And I know you've rehearsed it, but don't let it look like you've rehearsed it. Come out more in a natural flow of things. Abby, you made a statement to cover your tail. That's not really a vernacular that you should use in a courtroom. You know, you might say you're trying to cover up something or something like that rather than cover your tail. Now, when you're talking to a jury, that might work fine in your closing argument. He's just trying to cover his tail because people know what you're talking about, and so it's kind of personal. But when you're actually asking a question or something like that, you might want to be a little bit more, instead of using that kind of vernacular, use something different. I think as in the closing arguments, I agree with the comments that were made here. Always use rebuttal. Save something for rebuttal. In a case like this, you may not think that it means much, but you're really presenting a case. I mean, this is supposed to be like a real case. So you want to present it in the same fashion that you would if you were an actual lawyer trying a real case. And like has been mentioned, the prosecution goes first and they go last. So when you get up in your opening or your closing argument the first time, the defense has an opportunity to address some of the things you bring up. But then when you come back and rebuttal, they don't have that opportunity again. So as long as you might want to save some zingers for the rebuttal, always use it. And like I said earlier, I bet you know this inside and out, and I noticed, Pat, that you had probably 3 pages of notes you were reading from in your closing argument. I bet if you sat down right now, you could probably come up with almost every point you wanted to make without even looking at that. So you don't have to present your argument the way you wrote it out. Just present it in a logical manner and cover the points that you wrote out. So get away from the podium. Stand there and face the jury. Anytime you're talking to the jury, whether it's opening statement or closing argument, talk to them like you're communicating with them. And if you're reading, you're not communicating. So think about that as you go through the day today. If it's possible, I mean, if you freeze up on something, then look at your note. That'll bring it memory back to you and everything else. And I want to point out one other thing here. I wouldn't let you, I forget who it was, present a witness who, it was about the time on the sheet. You wanted to present the receipt as evidence to the jury or to the witness, to let that witness refresh their recollection because she stated the wrong time. You can't, under the rules, you can't do that. So I wouldn't let you do it. Your coaches may have told you that in reality that's how you might present this, and it would be if a person could not remember, then you would have that to refresh their recollection, and that in a real case that would be legitimate. But in a mock trial, it's not, and that's the only reason I wouldn't let you do it. If this had been a real case, I would have let you do it. So we're working under certain rules here. And so we have to abide by those rules, even though in a real case you might have been able to present something. So it's a good job. Good luck the rest of the day. You've got your feet wet, and just like the lawyers over here told you, every one of us. And I was a trial lawyer in the prosecutor's office for a lot. I've tried hundreds of cases, jury trials, and every single time I walked into that courtroom at the beginning, I was nervous. It never went away until I asked the first question or stood up the first time. Then it all went away, you got into the flow, and away you went. But if you weren't nervous going into it, then you weren't sharp. So if you're nervous, it's because it's new to you for one thing, but also because you're keyed up and ready to go. So you ought to be able to settle down a little bit once you start going into it, and I noticed some of you did. I think that's a natural thing. So if you were walking into a courtroom and you just didn't care, then you shouldn't be there. So it's not an unusual feeling at all. Congratulations to all of you and good luck.